Hello, good afternoon if you're on the East Coast, and good morning if you're way out west. You are listening to Responding to Government Investigations in Higher Ed, a focus on Title IX and gender equity, which is part of Thompson Coburn's Higher Education webinar series. And while folks are jumping on board, we'll tell you just a little bit here. We'll do some preamble to the presentation. If you don't know us, Thompson Coburn is a law firm, US based, headquartered in St. Louis, but we have offices, substantial offices generally around the country in major markets. And we have a group of attorneys who spend all or most of their time serving institutions of higher education. So that's sort of our higher education practice. Some housekeeping while folks are getting ready. First of all, you have a Q&A widget on your screen. Hopefully you can see that there. We're going to go through the presentation and then we're going to take questions at the end. So we encourage you, if you have questions as you're listening, please log those in through the Q&A widget. And then at the end of the presentation, I'll moderate those questions and our presenters will get you good answers, I'm sure. There's also a resource widget. A copy of the slides for this presentation are there in the resource widget. And there are, particularly, this presentation is sort of divided into two components. The first component is a little bit of an overview of certain of these Title IX and non-discrimination laws that are relevant to our discussion today. And then in the second half of the presentation, we're going to shift into panel mode and we're going to ask a series of questions to our panelists dealing with a fact pattern and then sort of a series of questions coming out of that fact pattern to which they'll respond. Particularly in the first part of the presentation, there are some links and other things that you may want to make sure to download and to be able to access. So all this is just to say, please take a look at the resource widget. The help widget is really there for technical issues. So if you do have some sort of technical issue during the presentation, you can look there. And then finally, a couple other things. First of all, like most of our presentations that are part of our higher education webinar series, this one is approved for continuing legal education. So if you're an attorney type looking for CLE, a couple of notes for you. Today's session is already approved for CLE in California, Illinois, and Texas. That's for 1 hour of general credit in each of those jurisdictions. In Missouri, you've got 1.2 hours of general credit. And in New York, 1 hour of professional practice credit for experienced and transitional attorneys. I assume that's some sort of official category. I'm not barred in New York. Keep in mind, CLE is awarded for attendance, right? So you're going to have some secret words that pop up during the presentation. If you are an attorney type looking to get that CLE credit, please make sure when the secret words pop up that you just take a second to click the appropriate button so that we know you're attending and we can get you all the credit that you deserve. By the way, if for some reason you are not able to get credit or something ever goes wrong, you can certainly just email us after the presentation and we'll work to get it worked out. Finally, there is a post-webinar survey. I say this every time we have a presentation. I could not mean it more. We always review those surveys and we review all the questions and the feedback, and we deeply appreciate that, and we use it to try to make each presentation better than the one before. Couple of other quick notes. We're going to talk about laws and in a couple of cases, we're going to talk about legal decisions that are out there. Just keep in mind this presentation is airing in June of 2025. So if you happen to be watching this on YouTube or some point later, or you're looking at those slides we talked about in 3 or 4 months, just keep in mind things could have changed. I referenced earlier, there are live links that are built into the PDF in a few places. So when you download it, you should be able to click on those and actually get to underlying resources. And finally, we've got our magic QR code here. This the presentation will be on our YouTube channel. A lot of our other materials, including our new litigation summary, our blog posts, all kinds of things that we create for free for the higher education community are on our higher education resources webpage. And you can get to all of that through this QR code. And we would be delighted for you to do that because that is why we created this for you all. And as you know, there's a lot happening right now. So we do have a lot of blog posts out there. The folks who do our litigation, higher ed litigation summary are working hard every couple of weeks to keep it updated, et cetera. So please take a look at those resources if you think they would be useful. We have, and we are featuring today a group of attorneys who are part of our higher education investigations and rapid response team. We recognized about a year ago that this was, even within sort of our general practice of higher education, a sort of a sub-practice that was very special. We have a group of attorneys who have particular experience in helping clients and institutions of higher education specifically to conduct internal investigations and to respond to government investigations. And that could be in the context of a government investigation like today, where we're talking about the Office of Civil Rights or Human Rights Commission or some other entity, an attorney general. It could also be in other types of matters, whether that's a key tom, whether you're talking about ICE or immigration on campus, et cetera. And this group all has sort of the types of skills and background and expertise to be helpful in those scenarios. Part of this group, we have a couple of former AUSAs, and they were featured, or at least Aaron Martin was featured in our first installment in this series that sort of features this group. Today, we're going to be hearing from, and you'll see these are the folks who are in red on the screen: Scott Goldschmidt, Stephanie Fredman, Leah Northerner, and Christina Cole. All four of these practitioners have particular experience. Several of them have worked in-house, and they have a lot of experience working with the Office of Civil Rights on Title IX matters and working with institutions to respond to those matters, often pre-litigation, right? So whether you've received a complaint or you've actually got the government engaged in an active investigation, working with schools to sort of prepare and respond to those types of investigations. And they will be your core panelists today. We're not going to go through all the bios right now, but we do, at the end of the presentation, we have profiles for each of your presenters. So if you want to look at that when you download the slides, you can go to the end and learn a little bit more about the four of them. So with all of that being said, I'm going to step to the side here and turn it over to Scott Goldschmidt to start us off with a little bit of a, an overview and a summary of the current state of the law. Scott, take it away.
Thank you, Aaron. I appreciate that. Appreciate the opportunity to be here and talk about this. And it's definitely an important issue for institutions, especially right now. As you might suspect, it's a whole presentation to talk about the law of Title IX, state laws, et cetera, that deal with sexual harassment, gender equity. Because we want to focus the majority of this presentation on the scenarios that we have later out, we're just going to kind of truncate this section, really a high-level overview of what is different, right, about the state of the law, really since the last administration went into place. So hopefully with that high-level overview, we can level set everyone with the right information and kind of give everyone the knowledge to move on to the scenarios, which we hope you'll find helpful. First thing to discuss, right, is the end of the Biden administration Title IX regulations. So for all of those that lived through the Biden administration's version of this, it was 4 years of proposed rule, an actual rule, litigation where half the country was part of these rules and half were not. And so it was a long saga, especially for those that had to implement them and write policies and try and have them in place. That saga came to an end in January 2025 after numerous states, numerous private parties kind of filing lawsuits. A Kentucky court vacated the rule in January 2025 with a nationwide injunction, basically because the Trump administration was about to come into the administration. There was no one left to defend the rule, and for our purposes, they kind of went away. And so when the Trump administration came in, a lot of things on day one. One of the first things they did in their first week was to write a Dear Colleague letter that basically stated what they thought the applicable law was. So this Dear Colleague letter said that the 2024 rule is enjoined. It's not coming back. We're basically just moving back to the 2020 rule, and we're enforcing the 2020 rule, which still affords protections, right, on the basis of sex. So in addition to the fact that we're now kind of in the 2020 kind of old Trump regime in terms of Title IX, a number of executive orders came out, right? And you've seen these in the news. There's a number of them that have come into play. There's two we're going to highlight here that are specifically relevant to Title IX and these types of issues. First one, EO 14168, defending women from gender ideology extremism and restoring biological truth to the federal government. This was a day one executive order, kind of really gets to some of the priorities of this administration, emphasizing, and you'll see this kind of repeated in these intro slides, this administration's focus on the biological reality of sex, rescinding Biden guidance, then defining sex kind of as an immutable biological characteristic. Second executive order we want to highlight is EO 14201 in the Title IX space, right? This is keeping men out of women's sports. Two stated policy goals, right? To rescind funds from programs that in their words, deprive women and girls of fair athletic opportunities, and oppose male competitive participation in women's sports, right? And as you've seen in the OCR decisions of kind of what cases they want to open have been really focused on this. And again, in the full webinar in Title IX, we would get into the OCR decisions and the case law, et cetera. But for our purposes here, this is certainly a priority of this administration and one that they've started to enforce with OCR. So in addition to executive orders, there's a number of other actions across the administration that this president has taken, right? So in February 2025, along with the EO, the White House issued a fact sheet on women's sports, provided additional details, and stated, right, for the executive branch, which is really what these executive orders are focused on, that the EO requires immediate action, enforcement against schools, locker rooms, et cetera, that deny women's single-sex sports and single-sex locker rooms. And so for our purposes, we've seen this come into place, right, that the administration has been working on these initiatives. We've also seen in the same month a memo from the acting attorney general that takes the position that the Department of Justice, that the Bostock ruling, Bostock was a Supreme Court decision kind of back in the first Trump administration based on Title VII, but the Biden administration used the holding kind of in the Title IX context. This administration made their position clear that Bostock does not mandate gender identity access to single-sex spaces or athletics. Similarly, HHS, another agency that's also involved in education a fair amount, right? They publish sex-based definitions as guidance for the U.S. government and partners, and basically use these definitions of sex, as you might suspect, that a biological characteristic in line with how the administration has been defining these. Also important, two initiatives that both the Department of Education and the Department of Justice have recently announced, or we think are worthwhile. So the first, Education and Justice announced a Title IX Special Investigations Team, right? And so in their announcement, they noted a staggering volume of Title IX complaints. They noted that a focus of the team, again, the themes before, will be protecting female athletes. And the goal of the team, right, is to streamline Title IX investigations by creating this specialized team of investigators from across education and justice. Really important, I'll draw your attention to the last sentence of that quote, right, that the investigations are fully prepared for ultimate Justice Department enforcement. So a lot of schools are very familiar with the Department of Education and enforcement by states, maybe not as much with the Department of Justice, but here and in the next initiative, this administration seems to be signaling a much more aggressive role of the Department of Justice. And again, this is something that maybe has come across your campus and has kind of raised the hackles of a lot of administrators across the institutions, right? But the DOJ established a civil rights fraud initiative. And so basically with that initiative, they said that they're going to utilize the False Claims Act to investigate and pursue claims against any recipient of federal funds that knowingly violate civil rights laws. And for all institutions that accept federal financial aid as part of the Title IV federal student aid programs, that would apply, right? And this has always been a avenue for the government, but not traditionally kind of used in this way. And so here we have the Department of Justice coming out and saying, we're encouraging private litigants to use this. And not only are we encouraging you to use this enforcement, but you get to share in some of the monetary claims, which can be fairly significant. So a really important piece for institutions to be aware of. Not only do we have government potential investigations, but private litigants as well can use this initiative under the False Claims Act. Last piece of the overview is just to kind of to get a sense of where we are. We've talked a lot about the state of the department in general and the risks taking on, but particularly for this presentation, the Office for Civil Rights was also significantly affected. So in March 2025, hundreds of OCR employees were laid off. Offices in Chicago, Philly, New York, Dallas, San Francisco, Boston, and Cleveland were all closed. Prior to the layoffs, OCR had about 550 employees. Our best reporting seems like they've come to about half, about 240 employees. And these layoffs have resulted in an increased caseload for investigators. And we'll talk about maybe some of the effects of that moving forward. But that is the highest of high-level overviews, Aaron, just to kind of get us started.
Thank you, sir. Very much appreciate that. That brings us actually to our first secret word of the day. So again, for those of you in particular who are looking for Continuing legal education credit, please take a minute here on your screen. Today's first secret word is summer. How apropos. Please select the correct secret word from the choices shown below. I'm reading that just to make sure I get it right. So fall, summer, and winter are your choices. Please pick summer. That is the season we are in, or at least that I think most of us would consider us to be in. I'm going to leave that up on the screen here for just a couple of more seconds. And want to make sure, let's see, we're watching. One of the nice things about the technology these days is it shows me the percentage of folks who have actually responded to this question. So we'll give it just a second more. And by the way, while we're doing this, I'll just note, you'll see at the end, we have an invitation to our NACUA event for next week's conference. It's going to be in Seattle, and we'll pull it up on the screen towards the very end of the presentation. But in case you leave early or otherwise miss that, we just want to make sure to say, if you are going to be at NACUA next week, please look for us. We have an event on Monday afternoon. It's the half day, so it's right after the half day lets out. It's going to be at a rooftop there in Seattle. It should be a lot of fun. If you're in town, you're there for NACUA or otherwise, please come see us. We would love to say hello in person because we know a lot of people join us online and we don't actually get a chance to shake your hand, and thank you for your attendance. All right. With that being said, now we're going to shift into the second half of the presentation. We noted Scott was going to start with the overview. Let's get into the fact pattern and the questions. I will start by just reading us through our fact pattern, and then I'll tee us up with our first question, which I'm going to direct, I think, initially out of the gates here, Scott, to you, and then we'll get Leah, Stephanie, and Christina involved. So here's our fact pattern just for everyone. And this sort of sets the table for all of our questions. So we'll go through this at a moderate clip to make sure everyone has a chance to process it and absorb it. So Jordan, a senior, works part-time in the Thompson University Library. See what we did there, the Thompson University Library, as part of the Federal Work-Study Program, so one of the federal financial aid programs. Jordan is a peer supervisor to other student employees at the library. So again, we've got Jordan. She's a student, a senior, works part-time in the the Thompson University Library as part of the Federal Work-Study Program, and is a peer supervisor. Taylor is a freshman, also a student, a freshman, was recently hired in the library as part of the work-study program. Jordan begins lingering at the front desk to talk to Taylor about non-work related topics. Over time, Jordan begins making flirtatious remarks during training shifts and sending unsolicited social media messages, as well as a suggestive meme via a university group chat. Okay, so again, over time, Jordan, our senior, begins making flirtatious remarks during training shifts and sending unsolicited social media messages, as well as suggestive memes via a university group chat. Taylor begins to feel uncomfortable, but hesitates to report the conduct, concerned it could jeopardize the job or appear unprofessional. After particularly unsettling interaction, where Jordan made a suggestive comment in front of another student, Taylor discloses the situation to a library supervisor. So, and we wanted to make this point here at the outset, right before I switch over. Maybe Scott, you can comment on this, or Leah or others. But, here we're going to assume that you, through this claim as an institution, have learned of this potential issue. We're sort of going to jump off there. In this case, the government has not yet been involved, but we acknowledge that you could just as easily have a situation where the first time you learn of this scenario or this fact pattern is actually from the government. So just keep in mind, as you all know, at institutions, the first time that you hear about an issue, sometimes it's from a student filing a claim internally with the institution, or sometimes, I will say, unfortunately, less fortunately for an institution, the first time you hear about it may actually be when the government reaches out to you. In our case, the government's not involved yet here. We're dealing with a complaint that's being filed, or brought to the attention, I should say, of the institution. So you receive a call from the library supervisor asking for advice, right? Because Taylor's brought this to the library supervisor. The library supervisor tells you that Jordan and Taylor are both scheduled to work tonight. Scott, turning to you here, what do you tell the library supervisor?
Yeah, thanks, Aaron. And it's a really great point, right, about when you can see, or when you get this claim. For our purposes, because we created the scenarios, we thought give a little fair warning, right, and kind of maybe start at the beginning, but certainly really important to note that a lot of times you get these claims directly from the government. right? So I think a lot of this too depends on your role at the institution. And we know there's everyone from counsel here to investigators to just administrators of the school. So I think we left the you also intentionally vague. And part of the answer is who you are at the campus and kind of what you do and what your role is. But generally, right, I think the first piece of advice, regardless of who you are, separate the parties immediately, right? And advise the supervisor, adjust the schedules, assign duties, don't have them work together that evening. Just a precautionary interim step to ensure safety, prevent additional misconduct. Again, these are things that you're going to be looking at potentially at a university hearing, the government's going to ask about, investigators, litigation, et cetera. So doing everything we can to put everyone in the best, safest position is important there. The second, under Title IX, and we're not going to get into as much of the Title IX regulations, right? Because we want to kind of get into the investigations piece, but really important to know here that you got to follow your policy, and your policy is going to determine how and whether you report, right? So remember, under the 2020 Title IX rules, which we talked about, that's the operative ones. Employees are not, the regulations do not require all employees to report sexual harassment to the Title IX coordinator. Your policy might, right? Remember, your policy still could report, could have this reporting obligation, but really important to kind of see what actually is there so that you're able to follow it. And again, that's certainly helpful for your defensibility. The library supervisor here might be considered an official with authority under the 2020 policy, depending on the policy and their ability to institute corrective measures. So again, reading the policy, reading how your institution defines the OWAs, they could be required to report, and that'd be something we want to tell the administrator as well. And if they're not, right, maybe encouraging, we always want information. We always want this report. So encouraging the supervisor to report factually, right, the who, what, where, why, and when to get to the office. I would remind the supervisor, it's not your job to assess credibility or investigate, right? They're not to question. You don't have to resolve the matter informally, right? Just report the concern and let the university process take hold and really kind of make that defensible record for you and the government investigation. Emphasizing non-retaliation of the university, right, or the school, reminding them that they're protected, right, regardless of making a complaint. They have their protection of the policy. And then last, like, document, right? We'll talk about this a little later, but documenting the date and time of the disclosure, the concerns raised, actions taken, and thinking about relevant evidence that might be not there or that might go away that you might want to consider solving or saving.
Yeah. Scott, can I ask just quickly, you talk about documentation. Who is in the context of it? I mean, at this point, we're doing this outside a government investigation has not yet been initiated, but let's assume we've got both scenarios. One where we learn about this pursuant to this fact pattern, maybe one where the first time we hear about this is from a government accrediting entity or some other third party. Who's doing the documenting here? Like who's keeping that records and where is it housed?
Yeah, no, great question. I think that leads nicely into our second question too, about who needs to be involved, right? And I think to the extent that it's the government kind of leading the investigation, involving counsel, your either inside or outside counsel, would be a really important fact. And I think that counsel determination, they would ensure the process is followed. I don't think they would be the ones doing the interviews, but kind of having them right up in front and center to document and kind of doing all the legal thinking and work is really important as well. If the government's not involved yet, right, I think the answer would still be that this is assuming this is an instance of sexual harassment. The Title IX coordinator in their office would be the one to be the primary point of contact to oversee the report, to coordinate measures, and kind of oversee the process. So in my last comment, it wasn't so much making the library supervisor the document. It was just kind of to be aware of those pieces. But other individuals that might want to be involved, right? The library supervisor to make sure that they're aware of the situation, the dean of students about potential supportive measures, campus police, right, if there's a security concern, and human resources if there is an employment concern as well, based on the student employee six.
And fair to say an institution's policy, in this case, Title IX policy, may dictate to some extent who should be involved, who should be contacted, et cetera.
100%. Follow the policy is a great theme for this government investigations webinar.
Yeah, very good. All right. Scott, any further comments here or good to move on, I think?
I think good to move on.
All right, let's do it. So now, Lee, I think we're going to turn in your direction. We've got, in addition to our fact pattern, the Title IX coordinator issues a mutual no contact order, right? Taylor and Jordan are moved to different shifts. Taylor later reports that Jordan liked several of Taylor's social media posts and was spotted waiting around outside Taylor's class. All right. Would this violate the no contact order?
I think that this is probably giving everyone who's ever done a Title IX investigation some kind of like Pavlovian response, because there's so many, this is so frequent that you get these alleged violations of no contact orders, actual violations. It happens, I think, in nearly every case that I have been involved in. Whether it violates, let's kind of take these one by one. So we have a social media post that one of the parties liked, and then the other one is that one of the parties was waiting around outside the other's classroom. So when we're talking about social media, this is really important to be thinking about, proactively whenever you're crafting your no contact order. We all love to have a template. It is super helpful to make sure you have everything in there that you need. But again, you need to make sure it has everything in there that you need, especially in today's day and age. Social media and cell phones, texting are probably going to be the biggest violations that you have of these no contact orders. So you really want to make sure that your no contact order covers that, right? First thing, check your no contact order. And then you also can consider where the contact took place or the conduct took place. Did the person like the social media post on campus or off? Of course, not forgetting that you still have an obligation to address a hostile environment that's created off campus by on campus by off campus conduct, even though we're not under the 2024 regulations anymore. So when we're talking about the social media post, we're really going to be looking at the no contact order, but it's probably going to violate it. When looking at waiting around outside of class, again, this is going to be another area you want to make sure that your no contact order is really tailored to the specific case. You want to know these two parties, do they have classes together? Are they going to be in the same area at the same time? Is it sufficiently severe enough that you may want to alter their schedules? Or could we put in an exception into the no contact order, that them passing in the hallways for this, this particular class does not violate the no contact order as long as there's no actual, communication or something like that. So of course, always wanting to look to your no contact order for the specifics, but generally these probably would violate your no contact orders.
Yeah. So, moving past the no contact order specifically and thinking more broadly, you've now got this additional information, no contact orders in place, some additional intel about, the extent to which it is being complied with. Next steps, what do you think?
Next steps are really important, because what I see a lot happen is that, you get these kind of blinders on, you're doing your Title IX investigation and you're investigating, and you don't pay attention to the fact that there could be other Title IX violations that are occurring during your Title IX investigation, right? So you're so focused on conducting this investigation and you're doing it absolutely right. But perhaps whenever you get that government letter that they're investigating now, they're looking at everything and they're saying, well, but you never investigated this violation of the no contact order, or you never looked into these other situations that occurred. So that's something that's really important that we're making sure we're doing on the front end, is responding to these. So you want to consider whether this violation of the no contact order on its own, does that rise to the level of a Title IX violation, such that you would need to open a new Title IX complaint and consolidate it perhaps with the ongoing complaint. And then, of course, you're going to look at that no contact order and see what the remedies are within that no contact order for, a punishment for violations. How does it handle violations within your no contact order? You really want to make sure that those are spelled out in your no contact order for situations like this, especially because under the Title IX regulations, we all know that we can't punish anyone for their involvement in this case until we have a final disposition of what happened here. But if we do have those remedies and things that are built into the no contact order, we can impose those, even though the case is still ongoing, because it's separate from punishing for the alleged Title IX violation, if that makes sense. So you'll want to look at your normal discipline policies in conjunction with what's built into that title or that no contact order, and make sure that you're addressing it so that when the government, or if the government does come knocking, that you have made sure that you're addressing not only the underlying complaint, but also other things that are happening around it as well.
Yeah, very good. Thank you, ma'am. Additional thoughts there? That sounded pretty conclusive. Shall I move on?
Yeah, I think that we're good on the no contact orders.
All right. So now Taylor files a formal complaint, right? This issue's been raised, and now Taylor, you have the no contact order. Taylor's feeling a little uncomfortable about whether that is really being fully complied with. And at this point, Taylor decides to file a formal complaint. The Title IX coordinator reviews the facts and asks if this situation should be treated as a Title IX matter, an employment matter, or both. Remember, both of these students are part of the federal work study program. Stephanie, turning to you, who one is in St. Louis. I should have mentioned to our listeners, our viewers, we've got Scott is in Washington, D.C., and Leah is there in Dallas along Christina, and Stephanie and I are both here in St. Louis, Missouri. So we're all over the place today. And Stephanie's one of our former post-secondary administrators. So very interested in what you think. How do you navigate scenarios where an individual's identity as a student and employee is relevant?
Yeah, thanks, Aaron. I think these issues come up a lot, and I think that it's a really interesting question. And the just very sort of basic answer here is that you have to consider both the individual as a student and as an employee. Here, you're going to have Title IX implications, but you're also going to have Title VII implications as well. And there also might be state laws that apply both to a student and or to an employee. And all of those things need to be considered when, and even before the formal complaint is made. Here, the fact the formal complaint does sort of start this Title IX process, but that does not mean that the employee component of it should be ignored or is no longer relevant, because it is certainly relevant and certainly important to consider. Title IX indicates that when you're looking at how to go through your grievance procedures and how to actually think about a student employee, it's looking at what is the relationship between that individual and the school. So is it that they're there for the primary purpose of getting an education? Or are they there for the primary purpose of employment? And that's sort of one way to think about this in terms of that Title IX component and how you're going to go through the Title IX process. But as Scott said at the beginning, you also need to look at your policy. You need to see what's in your policy and how you might address these things too. If your procedures also indicate a certain way for investigations of employees and or students, then that needs to be the thing that you're following, as long as it also is in compliance with Title IX. Right. And Aaron, I'm actually just going to jump right into the second question here because it segues really well. And so when you're thinking about other policies that might be implicated, there are a whole host of policies that might come up in this scenario. So not only do you have your Title IX policy that you're going to look at in terms of once that formal complaint under Title IX comes in, what are the next steps? You also are probably going to have equal employment policy, or a policy that might be a standalone policy that addresses just discrimination in the workplace or sexual harassment in the workplace as well. And those policies, while they may be similar or may go hand in hand with what your Title IX policy is, they may have different components too that need to be considered on how an issue is investigated, who needs to know about it. So at the beginning, Scott mentioned that HR is somebody that you should be looping in right from the beginning if you know that this is an employee. So that person may not be the same person as who's doing the Title IX investigation. So you may have a secondary investigation happening from an employment context as well. And then too, keep in mind, the complaint coming from the government, while could be on OCR's side, you also may get a complaint from the EEOC or from the state, and ensuring that you have followed your policies as they relate to students and employees is important and really crucial here.
Yeah, understood. All great points. Okay, back to Thompson University. The institution's located in a state that has additional requirements for sexual harassment investigations for students. And Stephanie, you were just alluding to this a little bit, that you might have other sort of frameworks with which you have to comply. But we'll, Christina, come to you and back to Dallas, as it were. How do you navigate state requirements when you're talking about Title IX?
Yeah, well, unfortunately, it's a little bit of a lawyerly answer in that it depends, right? But first and foremost, as we've been saying, consideration towards both has to be given, right? That's where we start. We need to make sure that we're aware that these additional requirements actually exist, right? Some people will look at Title IX fair process as kind of like a cure-all, right? We followed that fair process to the T. There's no way we left room for any risk of litigation, right? Not always true. So yes, make sure you're following the fair process. Make sure you're providing that. And if there's no conflict between Title IX fair process and your state, requirements for sexual harassment or discrimination, then, no additional changes are needed. But if there are conflicts, then that's where we can really get into the meat of some additional friction where we need to make sure that we're staying on top of things, right? So let's say, state law conflicts in some way, right? Then you really need to give some thoughtful consideration to how you're conducting the investigation, right? So I'm going to give a couple of examples. I've got a lot of California experience under my belt, so I'm pretty familiar with the conflicts that occur in California between state and federal law. So we're going to use that as kind of an example for any other jurisdiction and for wherever our listeners are today. So our first example is under the California Fair Employment and Housing Act, right? There's a requirement for a prompt investigation. It has to be prompt, their own fair. Prompt being part of what can cause issues and conflict with Title IX. So when you come across a sexual harassment claim, like our example, then you're going through your Title IX process, which can sometimes be very long and drawn out because you have to make sure that you're providing notice. You have to make sure you're providing evidence to both parties in time to review. Then maybe there's this additional no contact violation that then you have to do an additional investigation, and that might elongate the process, right? So there can be a lot of conflict between making sure you're dotting your I's and crossing your T's in your Title IX fair process, and then providing this kind of prompt investigation, right? So
very good.
Under California,
Yeah, go ahead, Christina. You still there?
Yeah, I was just going to say that kind of promptness description can be as soon as feasible once, initiated, but should conclude quickly in order to address and stop the harassing or sometimes discriminatory behavior. So a lot of times what you can do is take these kind of remedial intermediary steps to try and address the harassing and discriminatory behavior in order to, maybe not in a prompt investigation, but through this different avenue, address and quickly put a stop to the behavior, right?
Yeah, very good. Other states that you think are particularly challenging to work with, or at least to reconcile with Title IX, or is it just hit and miss?
Well, it depends on the state, right? There are a couple of examples that I can provide, like, what actually triggers the investigation, under Title IX, our 2020 regs, not 2024, you have to have a formal complaint, right? That's going to trigger it. But like we were talking about just prior, and what Stephanie was kind of alluding to, that maybe there's an additional labor and employment investigation that's getting triggered that doesn't require a formal complaint, right? So under California, it's the same thing, that you just need to have an informal complaint, and then that's going to trigger a duty to investigate. And since we have students who are both students and employees of the university, you're going to have that issue here.
Right. And another example that I've thought of at times or seen is where you might, you've got a federal framework that permits you, for example, to potentially send home an employee or a student in an expedited basis, understanding there may be some set of requirements that have to be satisfied to do that, but you might have a state law where you're not permitted to do that at all, for example. So in which case you're sort of trying to satisfy the heightened level of process likely for that student or employee. And it's fair to say that's you need to talk with counsel, you need to look at the requirements. But when you have tension, typically the idea is going to be, if one framework is more permissible than the other, then you probably need to look to try to comply with the one that is less permissible or sets the higher bar, however you want to think of it, metaphorically speaking. But is that generally right?
Yes, I would agree with that.
Yeah. It's not an easy thing to do for certain. And I'll just add for folks, tying this back to sort of the government investigation concept. I mean, I understand, what we're talking about here is responding to government investigations. And right now we're still happening at the school level, but keep in mind, if and when the government gets involved, what they're going to look at, among other things, not only is whether or not you're complying with the various federal or state or other requirements that are out there, but also, as Scott mentioned earlier, or maybe Leah, but the policy, your own policy. I once had a litigator say to me, the best advice I can give you is if you have a policy, follow it. So, when you've got these situations evolving or unfolding, even prior to potentially having a complaint filed with the government or the government investigating on site, it's just important to keep in mind that handling them in accordance with your policy and to the best of your ability in accordance with state and federal law is going to put you in a much, and documenting your compliance with those things is going to put you in a much better place if and when the government actually comes on board, right? So we said at the outset, you may hear from this the first time you get this complaint or learn of it may be from the government. But if it's not, if you're learning about this at the institutional level, it's critically important to sort of take these steps and start building your record and complying with your policies and to the best of your ability, reconciling and complying with state and federal laws so that when the government gets involved, you have a really strong starting point for managing any kind of response or document production or other inquiries that you may get from that government agency. Moving right along, I think we're back to Scott, to the top of the order, as they say. The investigation commences, Scott, and at the start of the investigation, Taylor, and by the way, just to clarify, in our fact pattern here, we're talking about our internal investigation, correct?
Yes, at this point, yes.
For you, Scott. Yeah,
correct.
Just want to make sure to clarify that for everyone.
Absolutely.
So the internal investigation commences, and at the start of the investigation, Taylor comes to your office. Taylor's our respondent, right? Our complainant. Taylor comes to your office to file a separate complaint alleging Jordan vandalized her dorm room. Okay, so now we've got two complaints, right? Both filed by Taylor, right? One is our initial complaint involving Jordan's potential sexual misconduct, and now we've got a separate complaint being filed alleging Jordan vandalized Taylor's dorm room. What are best practices for investigations?
Yeah, so this is a great question, and I think this internal investigation, right, can come either after the government comes into play, or certainly if you get a notice from internally. Like, what do you do at this point? I'm going to punt on this one, Aaron, just in the interest of time. I want to make sure we try and get to the other ones. I will put a shameless plug out. Aaron and I spent a lot of hours doing a Title IX webinar series many years ago when this first came out. We have a whole module on best practices for investigations with some really smart people besides me and Aaron, retired judges and kind of our partners. So please take a look at that if you have any questions about the best practices for investigations. I think the interesting piece for this question is kind of how do you address a vandalism complaint? And this happens a lot, that people make a complaint and then there's other things that happen, right? Usually the Title IX complaint obviously would be under the Title IX policy in accordance with federal regulations and state requirements. The vandalism complaint likely would be governed by your code of conduct or similar piece. So how do you kind of deal with both? And realizing that the processes are very different. The Title IX complaint has a very kind of lengthy list of procedures, cross-examination, notice requirements, where your conduct code likely does not have those type of requirements.
Right.
Absent an exception, which I'll talk about in a second, most likely you'll do these on a parallel track, right? do the procedures relevant to each, ensure the vandalism investigation is handled by someone not involved in the Title IX investigation. It doesn't influence the Title IX investigation, and there's a kind of a clear firewall in each case, making sure that kind of there's the separation, but also communication occurs because there's two things going on. Everyone knows the responsibilities. The exception is if the vandalism is alleged to be in retaliation for participation in the Title IX process. So under the federal regulations, you have to determine if that was retaliation, then it might be part of the Title IX investigation under those procedures. Also remember, as part of the process, you'll have to provide additional notice if claims change, but hopefully you'll be able to kind of deal with them in a parallel way because it just be a little cleaner that way.
Yeah, very good. Moving right along. So Jordan, who identifies as transgender and uses they, them pronouns, raises concerns that investigators and supervisors have misgendered them during meetings, undermining their trust in the process. All right, interesting. So we're back to you, Leah. Does this trigger the Title IX investigation?
So this is a super tricky one, and probably one that everyone wants the answer to that's on this call right now, because we're seeing such a constant shift back and forth, like a ping pong game of Title IX and what classifies as on the basis of sex, and does it include kind of those LGBTQIA issues of transgender status and sexual orientation and all of that. And so, you know, like we have been saying throughout this whole presentation, you start by consulting your policy, particularly because you have all of those state elements that everyone has talked about. Many states have their own policies that protect things like misgendering in this case. And so you'd want to look at those policies, because your policies can also, even if you don't have a state law, your policy can be broader. The Title IX is kind of the floor, that you can add more things to your Title IX policy. And I know many of our clients have done so. So you want to be looking at your policy to see if it covers this type of conduct. And if it does, of course, utilizing that policy. But if your policy simply is referring to on the basis of sex, without any expansion of that, then we're looking at what is required by the regulations. And, you know, we're back in those reinstated old regulations, the new old regs. And under the way that those are currently being interpreted, it probably does not trigger a Title IX investigation. As we stated in the beginning, the new administration has really made it clear that they consider discrimination on the basis of sex to be about biological sex only. And the administration has also said that it does not consider that holding in Bostock that said discrimination on the basis of sex includes gender identity to apply to Title IX. So therefore, the conduct, even if it was proved, it likely would not constitute Title IX sexual harassment as this current administration is defining it. But that is another important thing to remember, is that we're under these new old regs. And so these old regulations don't cover sex discrimination as we thought of it in the 2024 regulations. We're back to that, the regulations only covering Title IX sexual harassment. So the misgendering in this scenario, even if it did cover, even if it was covered under Title IX, would need to meet that definition of hostile environment. So it would need to be severe, persistent, and pervasive. And it's unlikely, although not impossible, that misgendering in one or two investigative meetings would rise to that standard. So you probably don't need to open a Title IX investigation, but you do have other obligations to address this conduct, either in policy. There's also different standards in court. Even a Title IX allegation in the court system is handled differently. And it's possible that this could fall within Title IX in the litigation context. So you should definitely still respond and make sure that you are not acting in a deliberately indifferent manner. You may have heard that term. That's kind of the litigation standard. But again, this is a very tricky situation. So if you have something like this come up, make sure that you're looping in either your in-house counsel or your external counsel to make sure that you are getting the most up-to-date updates on the law as it changes. It feels like every minute these days. And then also to make sure that you are applying that to the specific allegations, because there are ways that certain things may not fit in some areas, but may fit with just a slight tweak. So we want to make sure that we're looping the counsel in on that.
Yeah, and Leah, I guess the follow-up question here is one I assume many people would be asking, which is, okay, but we already have another Title IX investigation going, right, of Taylor's complaint with regard to Jordan's conduct. How does this affect that investigation?
This is an important one, and this kind of goes back to, how do you want to position yourself to make sure that if you do get a government investigation, that you have done everything right, you've ticked off all your boxes. And one of those big boxes is making sure that your investigation is free from bias. And it is possible that this investigator's misgendering of one of the parties in this case could be evidence of bias and unfairness in your investigation. So you're going to want to look into it further and do kind of a little, I call them big I investigations. Those are your capital I investigations, and then you have your little I investigations. You want to do like a little I investigation where you're just kind of looking into what happened here and talking to people and seeing if you think that the impartiality of the investigator was really affected or really called into question by this misgendering, or was it an accident? Is it something that we think is going to affect the outcome in this case? And if so, you may want to just kind of scrap it and start over from scratch so that you have an investigation and a result that really can stand up if it were to be challenged.
Yeah, very good. All right, we got about 10 minutes left, so I want to make sure to get to these last two bits. Stephanie, back to you in St. Louis. Taylor is registered with disability services. And I know folks might be thinking, boy, this just keeps like, but this is real. Those of you at institutions know, like, these types of complications come up all the time. So Taylor is registered with disability services. After a report is filed, Taylor's advisor contacts the Title IX coordinator with concerns about discriminatory treatment based on disability during this process. How does this affect the proceeding?
Yeah, so I think one thing to keep in mind is the requirement that the complainant and the respondent be treated equitably. That's something that runs throughout Title IX investigations, and it's something really to be considered in this specific context with this scenario. But generally, it's not going to affect the proceeding, but it's going to add additional thought and consideration and potentially and likely investigation into what's going on here. So, one of the things that it's not actually written into the scenario, but some follow-ups that I think are important is to learn whether or not does this student, does Taylor have accommodations? And if so, and if you're aware of those accommodations, how can those accommodations be applied, and can those accommodations be applied to the Title IX proceeding? If accommodations are in place, they do need to be in place through the proceeding. And those, as I'm sure you all know, those accommodations can range. They can be anything from just needing information to be given to a student in a different manner, or even if you're thinking about time to respond, maybe the student needs additional time to respond to certain things. So I think all of that is important to take into account when thinking about how it's going to affect the proceeding. I also want to note that when there's a concern about disability discrimination, there also should be, a little red flag that goes up as well, indicating that OCR may come at you with a complaint by the student that also is looking to enforce Section 504 or the ADA. And you then are going to need to respond to those complaints as they relate to a claim of disability discrimination. So really understanding, what the allegations are and looking into that and doing sort of a separate investigation to ensure that there is no disability discrimination that's occurring, and that, that equitable treatment for the complainant and respondent throughout is happening, I think is something that's going to be crucial as you're looking to the next steps here, and considering that there may be a complaint that could come in from the government addressing some of these issues of discrimination and or harassment, depending on what it looks like.
Yeah, Very good. All right. Additional thoughts or good to move on?
No, I mean, I think most of that was covered in terms of who else needs to be brought into the discussion.
Right.
You just, as a note, you may have other individuals in disability services or your Office of Disability Services who are tasked with the investigation of those types of complaints. So ensuring you're looping those people in and making them aware of any complaint of disability discrimination, it's important.
Yeah, very good. Great note. I mean, I've had situations, I'm sure others have on this call, where either a complainant or respondent has in fact been someone who's registered with disability services and has a need for accommodation. So it certainly does happen. Christina, coming to you here for the end. Taylor, dissatisfied with Thompson University's pace and communication, files complaints with both the U.S. Department of Education's Office for Civil Rights, the State Human Rights Commission, and the local police department. So 3 separate complaints at the state, federal, and municipal level. How does the state of OCR affect this complaint? Not meaning the state is in like the government in it, but like the status of the Office of Civil Rights at the moment affect this complaint?
Yeah, so as we mentioned before, OCR has had drastic changes, a lot of cuts, right? It's our understanding from certain communications that we know their caseload has greatly increased, right? That maybe some of these investigators went from 100 cases to now they have 500 cases, right? That just one of them is handling and going through. So that may result in the fact that you may not hear from them for a while because they have such a huge impacted caseload. Maybe the investigations are primarily going to be handled by the state equivalent rather than OCR, right? So you're going to be communicating more with your state civil rights department versus the ED's office. And maybe it means that you're going to have to hold on to documents for a little bit longer because their process is taking longer because they have these higher caseloads, right? So you're going to want to take those things into consideration, that maybe those processes that you've been accustomed to might change a little bit.
Yeah, for certain. And I'll add, I mean, you may have to be thoughtful. Sometimes these things can drag out for even months or years. And if that happens, if parties are departing or employees, make sure you've got their records or notes or other things, that where those are once they've gone so that you can get to them. There's a lot to managing processes that extend over a great deal of time. But to Christina's point, maintaining the documentation, being patient, being sure that who's in charge at the agency or been assigned your case, all of those kinds of things. It just takes sort of attention. I'm going to ask you this second question, Christine, and then as you're answering for the folks on the line, I'm going to go to our second secret word of the day here at the end of the hour. I want to make sure you get to that. So, Christina, the question is, how can an institution handle a complaint investigated by multiple state entities? And while you are answering that question, I'll ask folks to make sure to hit C here, break, which is our second secret word.
Yeah, so part of that goes back to what we said, is making sure you're communicating with the right entity, right? Are there 2 simultaneous investigations going on, or is there one but 2 complaints, right? So you've got 2 case numbers, but you've got one entity conducting the investigation. Make sure you're clear on that. So that may require some communication with the investigators, right? I think the 2 main points here is stay consistent and communicate, because maybe there's going to be the police investigation, right? And so you're going to want to make sure that your policy provides for discretion to suspend your investigation while that criminal investigation is going on. So at least you have the option. Maybe you don't need to take it, but you might, depending on maybe the severity of the allegations, the involvement of the police and how involved that investigation is going to be. There also might be a benefit to being able to suspend, because then you can request the final report from that police investigation and then incorporate that into your investigation and conclusions, right? It's going to be a little bit of a cost-benefit analysis, because like we said, sometimes there are those state measures that maybe there's a prompt investigation requirement and the police are maybe impacted. Maybe they have a high caseload, maybe they're understaffed, and so it's taking a bit longer on their side. So those are things that you're going to need to consider as you're making sure you're staying in compliance.
Yeah, very good. Thank you, ma'am. Yeah, that's a hard one to do when you've got multiple investigations moving along at the same time. And you're right, that also takes a lot of coordination. Hoping everyone has had a chance here to put in C. I do have a couple of questions, but just before we get to those, I do want to note, and actually one of these relates to the question, we have a number of materials that we make available. Oh, actually, the first thing I'm going to remind folks is please, if you're going to be in Seattle next week on Monday, here's the invitation Monday afternoon to our event there at the Thompson Hotel. Boy, we're really leaning into this, aren't we? But that's actually a real name. There really is a Thompson Hotel in Seattle. Please come see us at 12:30. But the other thing I wanted to hit was we have this higher education resources page. And Scott mentioned earlier, and actually one of our questions, someone asked, how could we potentially utilize this training today and post it in response to or in fulfillment of the 2020 Title IX rules requirement that folks provide a certain type of training and that they post the resources utilized for that training on their external website. So I have two things for you here in response to this question. The first is, if you go to this QR code, if you go to our higher education resources page, you can see on your screen, this is just a picture that we've inserted here into the slide, but this is actually what the website looks like. And if you were to go to webinars and training resources and click down on that arrow and then follow that link, it'll take you to our YouTube page where we have an entire higher ed playlist, and it's got all our presentations, and it will have this presentation as well. You could go to that presentation. If you wanted to take that link and embed it in your website and indicate that you utilize this presentation, at least in part, in fulfillment of those 2020 Title IX training requirements, you are absolutely welcome to do so. That YouTube page is free. Also, I mentioned you can get to everything else that we make available to folks in the way of compliance resources, blog posts, and our litigation summary, which is great. But the other thing I really wanted to highlight is the thing that Scott mentioned a few minutes ago. We did a Title IX training series in 2020, in the summer of 2020, that was specifically designed for institutions to in part fulfill those 2020 Title IX rule training requirements. And we talked about the rule itself. And as Scott mentioned, we had a number of guest presenters, including frequent investigators, a retired judge who talked about managing investigations, managing hearings and complaint processes. We did one on appeals, et cetera. All of that is also sitting on our YouTube page. There's actually a separate playlist just for the 2020 Title IX training. Candidly, I think if you go to YouTube and just search for Title IX training, it's about the first thing that pops up. And there are multiple modules there, and you can email Scott or me, but those particular sessions we also have on our website in a place where you can download them. And so you can actually house them on your own institutional site. So if you are looking for training that is specific to the 2020 Title IX rule and will help you fulfill those training obligations, and training that you can actually download and house on your website, it's right there. We're happy for you to use it. So please feel free to do so. And if you have questions about that, you can reach out to me or Scott or Leah or Stephanie or Christina, and we're all happy to help out. But we spent a lot of time putting all that together for you guys to use for that purpose. So please, if you can't find it but you want it, just let us know. I think that actually brings us, we have another question that just popped in. Has the U.S. Supreme Court ever in history, so Scott and Leah, Stephanie, Christine, testing your catalog of knowledge about Supreme Court decisions, has the Supreme Court ever held that Title VII legal analyses applies in Title IX cases, since they both prohibit discrimination based on sex? So we're getting to this, relationship between Title VII and Title IX. I feel like Bostock may come into play in this answer. Maybe Scott, I'll throw this to you first, and then we can open up to the group.
Yeah, happy to. And I think the answer is yes. There are cases, Supreme Court or otherwise, that have utilized reasoning of Title VII and have noted the similarities there. Bostock potentially, Gebser, I think, as well. And again, if the commenter wants to reach out, I can get an actual answer instead of the top of my head. I think the main piece is the Bostock definition, Title VII, on the basis of sex. And that is the distinction, right? That the Trump administration in 2020, on the way out the door, put a memo out and said, Bostock, this doesn't apply to Title IX. Biden administration said, put it in the Federal Register. Yes, it does. Trump administration said it doesn't. And this is part, I think, just Alito's dissent kind of hinted at this, could be applied to Title IX. So I think there's still there is still certainly some debate over kind of what that means and how it is. But it's clear this administration does not believe in that reasoning for on the basis of sex in Bostock.
Yeah. But maybe worth noting that the Supreme Court, at least in its decision in Bostock, sort of went out of its way to say, look, the way that, the way these decisions work, at least in this case, the way it works, this is specific to Title VII. The legal issue was raised under Title VII. Our decision is specific to Title VII. And they at least in their decision said, we've not made a determination with regard to Title IX. And, we recognize that there's a distinction between these two laws, notwithstanding the fact that they sort of get at the same idea. Is that fair, Scott?
I think so. I'm curious what Leah and Christina and Stephanie think, but I think that is fair to say.
Yeah, I mean, I'll just add that there's clearly a ton of debate. So I think that there's, points on all sides. It's one of the big circuit splits that we have kind of going on right now is some states and some circuits are applying it. Other ones are saying no. And so that's why, we noted the fact that even though some conduct may not fall within the regulations and fall within the way you're required to respond in that Title IX investigation that set out in the regulations, you still could very well have a legal liability, a requirement to act in a certain way under Title IX in the litigation context because they're applying things differently depending on where you're located. So it is one of the big questions. I would love to see the Supreme Court finally weigh in on this one, but I don't know that we are going to get that, or at least it might be quite a little while before we do.
All right, we're 6 minutes over. Final thoughts from anybody else? Stephanie, Christina? Hearing.
No, thank you.
No,
thank you.
Hearing none. Yeah, very good. All right, then I'll just say thanks to everybody for tuning in. If you have time to do the post webinar survey, again, we really appreciate the feedback, including I'll ask specifically on this format, for our government investigations rapid response group, we've sort of been focusing on this format where we do a little bit of an overview and then we try to have a panel and get into some fact scenarios and sort of talk about them, which of course is different from when I do things on regulatory, et cetera, and just talk for an hour. So interested in your feedback on the format as well, if you got a minute and you have some thoughts. Again, thanks to everybody. Be safe. And until next time, be well.